17-year-old boy with perfect grades was pulled out of an admission queue on his first day at Achimota School, undoubtedly one of Ghana's most prestigious senior high schools. The school which shaped several leaders: Kwame Nkrumah, Edward Akufo-Addo, Jerry John Rawlings, John Evans Atta Mills, and Sir Dawda Jawara of Gambia. He was singled out not for his academics, not for bad behavior, but for his hair. This is the case of Tyrone Marhguy versus Achimota School and the Attorney General. Meet Tyrone in March 2021, a brilliant young man whose story begins with a dream and ends with a human rights revolution. This wasn't just any teenager. This was a model student with 6 ones on his PhD, who was a senior prefect of his school. But Tyrone wasn't just academically gifted. He was a devout Rastafarian, and that detail would spark a significant legal battle at the High Court of Ghana. Now let us paint you the full picture. Tyrone had been wearing his dreadlocks throughout his entire junior high school career. Not once, not a single time, did his hair cause problems. His teachers didn't just tolerate him, they celebrated him. When the media storm erupted later, these same teachers went on television defending his character and calling him exemplary. For Tyrone, those dreadlocks weren't a fashion statement or teenage rebellion, they were scripture in action. Numbers 6:5 from the Old Testament of the Bible was his guide. All the days of the vow of his separation, there shall no razor come upon his head until the days be fulfilled, in which he separateth himself unto the Lord. He shall be holy, and shall let the locks of the hair of his head grow. He would cite the biblical story of Samson, how his strength came from his hair, how disaster struck when Delilah cut it off. This wasn't an aesthetic choice, this was a religious mandate. Cutting his hair meant severing his connection to God. When Ghana's computerized school selection and placement system selected him for Achimota School, Tyrone was super excited. He had specifically chosen Achimota as his first choice because of its legendary Pan-African history, the school that shaped Kwame Nkrumah, the institution that embodied African pride and independence. It was perfectly aligned with his beliefs. Tyrone started preparing immediately. He bought his uniform, obtained the prospectus, and gathered everything that he required. The dream was becoming a reality. Then came March 2021, registration day. Tyrone arrives at Achimota School in perfect regulation uniform, a crisp white shirt, pressed trousers, everything by the book. His documents were organized, his fees were paid, and his heart was full of hope. He joins the processing queue with hundreds of other new students. The excitement is palpable. Students taking pictures, the beginning of a new chapter. Then disaster strikes. A female teacher spots him in line. She whispers to an assistant headmaster. They approach Tyrone like he's committed a crime. In front of everyone, his peers, parents, and other strangers, they pull him aside, asking him to cut his hair or go home. There was no discussion, no accommodation, and no consideration for his academic record or his religious beliefs. Just a cold, brutal ultimatum that shattered months of preparation. While his classmates moved smoothly through registration, Tyrone stood frozen, barred from his own future, over hair that caused zero problems for years of his education. The irony was evident. Here stood a boy who chose Achimota specifically for its Pan-African heritage, being rejected for embracing his African spiritual identity. The school that preached black pride was rejecting a black student for practicing black religion. But Tyrone wasn't going down without a fight. His father immediately took his case to the media. The story exploded across Ghana. Social media went wild, and everyone had an opinion. Now here is where it gets interesting. March 20th, 2021, just days after the incident, the Ghana Education Service itself issued a direct order to Achimota School to admit Tyrone Marhguy. The Minister of Education backed this directive publicly. The highest educational authorities in Ghana were telling Achimota that they got it wrong and it should be fixed. But Achimota refused. They ignored the GES. They dismissed the Minister of Education. Despite claims by the minister that the directive stood firm, word spread that it had been quietly rescinded. The pressure was immense. Tyrone remained locked out while his classmates started lessons. Every day that passed was a day of education stolen from him, not because of poor grades, not because of bad behavior, but because of his relationship with God. In March 2021, Tyrone Marhguy, suing through his father, Kwame Marhguy, as his next friend, filed a suit at the High Court. He invoked the court's human rights jurisdiction, demanding justice. His legal team filed for specific reliefs. 5 were declarations that Achimota's conduct was unlawful and violated his constitutional rights. 2 were consequential orders, demanding that the school admit him immediately and providing compensation for the harm caused. The rights at stake were not trivial. Tyrone's lawyers argued violations of his equal rights to education, his freedom of thought, conscience, and belief, his right to practice his religion freely, his human dignity, his right to administrative fairness, and his cultural rights. But the crux of the matter was crystal clear. Achimota's insistence that he cut his hair was simultaneously depriving him of education and forcing him to abandon his religious beliefs. It was a double constitutional violation. His legal team made a powerful argument. School rules cannot trump constitutionally enshrined human rights. The Constitution is supreme. No institution, not even prestigious Achimota, can create regulations that violate human rights and fundamental freedoms. Achimota School's response was swift and brutal. They didn't just deny the allegations, they called them falsehood and fabrications. They claimed Tyrone and his father were lying, using religion as a smokescreen to hide their real agenda, which was to break school rules. Their defense was ice cold. They laid out the numbers like a military briefing. 4,166 total students aging from 14 to 21 years old, and of these 1,758 were boys, every single one conforming to the hair regulation without question. Achimota argued their admission criteria had no recourse to age, color, race, or religion. They claimed to be religiously neutral, guided only by academic excellence and leadership. They pointed out that Tyrone himself had been offered admission on the same standard form as everyone else. Admission conditional on good academic work, good conduct, and strict observance of all school rules and regulations. Their arguments got clever. They produced Tyrone's signed admission acceptance form, his signature, his promise to abide by all regulations governing students in the school. They argued he had voluntarily accepted their terms, knowing full well what they required. The specific rule in question was Regulation H1 of the school's revised rules and regulations. Mustaches, sideburns, beards, and whiskers were definitely forbidden, and boys were to keep their hair low and neatly trimmed. Achimota's lawyers were relentless. They argued this rule applied to all students without exception. No favorites, no special treatment. Tyrone had not been singled out. He was simply held to the same standard as 1,757 other boys. They compared the hair requirement to other regulations: uniforms, house uniforms, sportswear, footwear, Sunday wear, and general appearance standards. These rules, they argued, had no reference to human rights, but were simply about orderly management and proper regulation. Their arguments, in conclusion, were devastating. That to grant this application would elevate Tyrone and his religion to a higher plane, to be treated differently from other students who each belong to various religions and creeds, but have submerged all their religious dictates to comply with Achimota school rules. This would be discrimination against other students and unlawful. The state's top lawyer, the Attorney General, also entered the battle with guns blazing as the second respondent. The Attorney General's office argued that Tyrone's rights had never been violated because, get this, he was never actually a student of Achimota school. Their logic was fascinating. Tyrone had failed to submit his acceptance of admission form, therefore he was never admitted, and thus he lacked the legal capacity to bring the action. It was a procedural tactic designed to kill the case before it reached the merits. In legal terms, capacity is everything. It is your entitlement to bring a lawsuit. Without capacity, courts won't even look at your case. They'll dismiss it immediately. The Attorney General was trying to win on a technicality. They also referenced Section H3 of Achimota's revised rules and regulations, which stated that students must keep their hair low, simple, and natural. They argued Tyrone could not claim that he was complying with school rules while simultaneously refusing to cut his hair. The state's top lawyer also portrayed Tyrone's father as irresponsible, claiming that he did not engage the school fully, but rather took to the media. They argued that allowing Tyrone to breach school rules under the guise of religious freedom would give him preferential treatment and lead to a breakdown of law and order. Their most powerful argument, however, focused on age. Tyrone was under 18, a minor. The state argued that minors could have certain liberties restricted in their own interest and in the public interest. School regulation existed for discipline, and these limitations were reasonable and proportionate. They warned the court of catastrophic consequences if Tyrone were to win, that there would be confusion and chaos in public schools, a precedent that would make management of public schools unduly difficult and challenging. The state's position was clear. Tyrone wanted to cherry pick which rules to follow. His claims had no bearing on religion, and granting his application would destroy Ghana's educational legal system. The court now took center stage. Justice Gifty Ejay Ado faced immense pressure. 3 very compelling narratives, a polarized nation where everyone had an opinion. Social media was agog. Traditional media had wall-to-wall coverage. The legal community was also watching. The stakes couldn't be higher. But Justice Ado did what great judges do. She followed the law. First, she demolished the Attorney General's capacity argument. She called it preposterous, a judicial slap that echoed through legal circles. Her reasoning was outstanding. Article 33 of Ghana's constitution permits anticipatory actions. Citizens can sue when they believe their rights are likely to be contravened. Tyrone didn't have to wait for the violation to be complete. More importantly, she noted the circular logic. Tyrone had submitted his forms, and it was Achimota School who had rejected them. It was simply unacceptable to argue in one breath that he was not a student and therefore lacked capacity, when that state of affairs was caused by Achimota School. The capacity objection was dismissed as without merit. Now came the main event, the conflict between the school rules and constitutional rights. Justice Ado laid out the legal framework with surgical precision. She acknowledged the trite position of law. Human rights were never absolute. They must always be balanced against public interests and other overriding considerations. Schools definitely needed regulations for discipline. Article 17's equality provision meant equals should be treated equally. But then came the constitutional divergence. Justice Ado evaluated Article 21(1)(c), which protects religious rights, alongside Article 28(4), which provided that no child shall be deprived by any person of medical treatment, education, or any other social or economic benefit by reason only of their religious or other beliefs. The language was crystal clear. The Constitution specifically protected children from being denied education because of their religious beliefs. This wasn't a general human rights provision. This was a targeted protection seemingly on all fours with Tyrone's situation. The judge declared that where school rules conflict with constitutional guarantees to practice and manifest religion, it is the school rule that is unlawful. She characterized Achimota's conduct as an attempt to project a mere rule or regulation to a lofty character that expediently prevented a person from manifesting their religion without reasonable grounds. Justice Ado noted the paucity of case law in Ghana on the same issue, so she looked beyond our borders. She cited very persuasive authorities from Kenya, Zimbabwe, and South Africa, all making the same point. School rules must accommodate genuinely held religious views and cannot be applied as though they were superior to the constitutional text. The legal test came from Ghana's own Supreme Court in the Closer case, a two-step analysis. First, is the limitation on the right necessary for the public good? Second, is the limitation too broad? The question then became whether the rule requiring students to keep their hair low, simple, and natural was reasonable, proportionate, and not overbroad regarding Tyrone's educational and religious rights. This is where Achimota's case collapsed. Justice Addo demanded evidence. Show us how dreadlocks harm education. Prove how they disrupt discipline. Demonstrate the hygiene issues. Explain how exactly they negatively impact student welfare. Achimota had nothing. Zero evidence. Not a single study. No expert testimony. No examples of problems caused by dreadlocks. No proof that Tyrone's hair would harm the school's stability or the student's education. The judge was explicit. There was no evidence on record to show how exactly the present state of Tyrone's hair will impact negatively on his own educational good or those of the student community. Without evidence, the rule failed the proportionality test. Fear and tradition was ruled to not be enough legal justification for restriction of constitutional rights. Justice Addo's final words were devastating. Achimota's insistence that Tyrone cut his hair before being admitted amounted to an illegal and unconstitutional attempt to suspend the manifestation of his constitutionally guaranteed freedom to practice and manifest his religion. This court will not fold its arms and watch such a violation. She found that pulling Tyrone from the registration queue violated his dignity. It was embarrassing and caused great inconvenience. Achimota had no lawful basis to interfere with his education. The orders from the court were immediate and comprehensive. Achimota School must admit Tyrone forthwith. The school was restrained from any further interference with his education, and their conduct was declared as illegal and unconstitutional. But here's the beautiful part. Justice Addo, thinking of Tyrone's future relationship with the school, chose not to order compensation. She prioritized his education over punishment, showing tremendous wisdom. The judgment was delivered. Tyrone Marhguy had won, not just his case, but a victory for religious freedom across Ghana. The boy who was pulled from the registration queue for his faith walked back through those same gates with his head held high and his dreadlocks intact. The school that claimed to champion African values had learned what true Pan-Africanism looked like from a 17-year-old with unshakable faith. The precedent was stunning. Schools across Ghana now had to accommodate genuinely held religious beliefs. The era of rules are rules, regardless of constitutional rights, was over. The supremacy of Ghana's constitution over institutional regulations was affirmed. Tyrone Marhguy didn't just win his case. He changed the conversation about religious rights in Ghana forever. He proved that constitutional rights aren't just words on paper. They are living protections that courts will enforce. Sometimes it takes one brave teenager to remind the most powerful institutions what justice really looks like. Sometimes it also takes one judge willing to follow the constitution instead of popular opinion. Sometimes it takes one case to change everything.